Thank you all for being here this morning. I'm going to start out. First thing is, spoiler alert. I don't know how you follow Steph Davis, but spoiler alert, I do not have any heart-stopping videos or photos. I tried. You know, I even tried a video of like filling out a certificate of insurance, but it just doesn't have that punch like free soloing El Cap. So spoiler alert on that. The other thing I wanted to mention is I kind of went a little literal on my presentation. I know, as in relation to the title of your conference, nuts and bolts of risk management, right? My presentation today is about some nuts and bolts kinds of things. But I do want to say, though I've got some experience in these areas, I think the experts on these issues are here in the room. So as we go through my presentation, please feel free to ask questions, but more important, share thoughts, ideas, best practices with the group if I'm touching on something that you've experienced in your community, with your organization, and you'd like to share some thoughts on how you handle that particular issue. It would be just wonderful if you did that. All right. Who agrees with this assessment? In our world, in the public entity world, our contracts haven't gotten any shorter or simpler. Is that right? Right? Who all here as a regular part of their job reviews and comments on or prepares contracts for your organization? We all do that? Is that as exciting as freeing El Cap? Probably not, but it's important stuff, right? Despite all this what seems to be increasing complexity and length of public entity contracts, right? At the end of the day, there's still a couple of simple truths that remain from my point of view. And that is a well-written contract, right, is really kind of your best friend. It may not seem like that when you're going through the contract and negotiating and wrestling with the counterparty to the contract to negotiate, but at the end of the day, if you've got a nice contract that you can turn to and rely on, that's really your best friend, right? Isn't it nice when an issue comes up under a contract, you sign it, put it on the shelf, everyone's performing, some question comes up, you can pull that contract down and you go, oh my gosh, yep, there's the answer. And everybody just moves on, right? But the opposite can be a little dismaying, right? What if an issue comes up and we've got a poorly written contract and we pull that off the shelf and we look at it, and kind of dismaying when we flip through it and it doesn't say anything about the issue that we have in mind, right? Well, that's kind of frustrating. Or maybe it's got some language in there and what does that even mean, right? Well, we thought to address it, but we didn't address it in a way that was clear. Or, sometimes a contract can be your worst enemy when you pick that contract up after a while and you're looking at it and you go, ooh, that's not good. Or maybe it's, looking back on that and go, why did we say that? Or why did they say that? People say the darndest things in contracts sometimes, right? You agree with that sentiment? Particularly after some time has passed, right? You go back and maybe you got a long-standing contract and you're like even a year or more into performance and you go and you look back and you go, that's kind of tough, right? So particularly when it comes to risk transfer, we want to make best friends and we don't want to have those dismaying thoughts about our contracts, and that's what I'm focused on in this presentation. I'm going to touch around some key issues and best practices around contractual risk transfer. I'm going to talk a little bit about contracting essentials, indemnification and insurance requirements, additional insured issues, certificates of insurance, and then remedies, which are a thing near and dear to lawyers' hearts, right? Because remedies is you're typically at that point in the contract when you're contacting the lawyers and figuring out what are our remedies if we decide to enforce this contract in a legal way. So I've got some thoughts on that. One disclaimer, my training, my presentation for you all today is simply a training resource. You all within your own organizations, I'm sure, have your own ways of doing things. You get your own counsel from your risk experts and your attorneys and so on, right? I'm happy to give you ideas and thoughts from my perspective, but recognize that if there's any inconsistency between the comments that I provide you from a legal perspective on some of the issues that we talk about and the opinions of your own attorney, you want to rely upon your own attorney's advice. Feel free to ask questions as we go through the material. I'm happy to do that. I just, one other disclaimer, in addition to there's no exciting videos or pictures here, is I have a pretty good radar for the what I call the live one. So if you have a question you'd like to kick around, if I get the sense, that that's the live burning question of the day, right? Sometimes it'll say, Sam, I've got a contract about this particular question. I've got this indemnification provision that we all want to sign, and my attorney says we can't sign. What do you think of that? That's probably not one that I'm going to jump into, right? So go work that out with your attorney, and you'll be in a good spot. But I'm happy to give you thoughts and suggestions. I usually wait until the final slide, presenters to kind of sum things up at the end. But I'm going to start off by telling you, here are my top, based on my years of experience, both in the pooling world and as a municipal attorney, public entity attorney. Here are kind of my top 5 best practices around contracting issues, preparation of contracts and contract negotiations. First, have an accurate and complete scope of work and payment provisions, right? That's where the significant amount of the source of frustration is, right? Scope of work and payment, we'll talk about that. For your independent contractor agreements, my number 2 suggestion, require indemnification from the independent contractor, right? And avoid giving it to the contractor. We'll break that down in a little bit. And if it's unavoidable, try and limit your obligations if in fact you find yourself in a position where you're going to agree to indemnify another party. Number 3, expressly in the contract require that the other party carry insurance of appropriate types and amounts, right? And require that your entity be named as an additional insured. Number 4, be careful in waiving remedies or in limiting your remedies. A lot of that may seem like endless boilerplate, right? It's usually in capital letters. Why is that? I don't know, right? It's like, oh, I'm going to read this extra carefully because it's in capital letters, but that's the remedies and the waiver provisions. Go through those closely and make sure you understand what you may be giving up if you're waiving or limiting remedies. And then finally, how many of you have for independent contractors, either for professional services or public works projects or other types of contracts, how many of you have your own forms that you use? Yeah, I strongly encourage you to do that if you have the resources to do that. And as important, put your vendors on notice, right? That you want them to use your form of contract, right? That kind of helps you from the get-go, right? If the initial starting point of the contract is the contract negotiation is we're going to use a document that our entity has prepared and embraces and knows all the ins and outs of, and you, the other party that's going to contract with us, you're the one that needs to go through that contract and figure out what points are important to you that you might like to negotiate, rather than the other way around, where we're kind of starting perhaps with our foot in a bucket if we're using a vendor's form, and then we're constantly battling against provisions that may be inconsistent with what you do within your organization, or are contractual provisions that really seem to be overreaching, right? Okay. Before I dive into some of the risk transfer stuff, and just talk about a couple of key issues, some best practices around some of the contracting essentials that are outside risk transfer stuff. First of all, a contract, just to break down basic stuff. And by the way, I hope that my tips are helpful to you, whether you've been doing this stuff for a long, long time or just started doing contract reviews, that you find some things that translate to what you're doing within your organization. But to break it down from an attorney's perspective, think of this. It doesn't take much to create a legally binding contract, right? All we really need is an offer, acceptance by the other party. There's got to be a lawful purpose to the contract. Parties, they call it a meeting of the minds in the lawyer's world. That just means we have to agree on what I'm given and what I'm getting, right? You can write that down anywhere, in any form, and you got a contract that's potentially legally enforceable, right? You, of course, have to have some consideration, and you have to have competent parties in the public entity world within your jobs. When's the last time you had a full-blown dispute about those kinds of contract basics? Hardly ever, right? Everyone agrees that we've got a contract in place. It's the more nuanced stuff. What was the scope of work? Who's responsible for this risk? Why do I have to pay this or that amount? I didn't think the contract provided for that. So those basics are there. That's all it takes to make a contract. But recognize that a contract that meets the bare minimum, right, isn't itself a great contract. Or as a lawyer friend of mine says, bad contracts ain't illegal, right? You can have a very poor contract and it's going to be enforceable, and that's going to be unfortunate if it doesn't run in your favor. So it's important to pay attention to some of the contract basics. Also important to recognize that when you receive and look at a lot of forms, not everything's a trap, but there are some traps, right? And beyond the basic minimums, make sure that the contract gets properly approved, that we get it signed, that it's got the payment provisions, and that kind of stuff. Pay attention to some of the basic contract essentials that will help you have a successful relationship with a vendor or contractor, right? Pay attention to those essentials, as I mentioned, including the scope of work, the payment provisions, and particularly the risk transfer provisions that we'll talk about in a little bit. The scope of work piece. How many of you actually help draft the scope of work in support of others within the organization? Or do they bring you a scope of work as a contract person? So who's in the first basket? We help folks within the organization translate their vision, what they need, into a scope of work. And how many of you are in an organization where it's like somebody who's another department director or somebody who's in this division says, this is what I need, put the contract together for me? Yeah. Remember that I think in my experience, the scope of work itself is probably the most underlooked part of the contract, but the most important part of the contract, because it really is the accountability tool, right? It's the part of the contract where we look to figure out what's going to be accomplished and what ends and products we're going to get, right? It's a little disheartening if our scope of work just consists of we hire someone for professional services, and the whole thing that the scope of work says is we will provide you with professional services, and it's got some big number that's a flat fee, and that's it. Is that going to be an adequate scope of work? Do we feel comfortable that if some dispute arises, that we have the leverage to hold someone accountable for not getting what we thought we were going to get, right? So it's important in putting together that scope of work to think about the work to be accomplished and describe it in terms of getting accountability from your vendor. Think about milestones. Do we want milestones for the progress of the work? Interim steps with actual deadlines to hold people accountable, right? The scope of work should break down the project into tasks with deadlines, right? It's hard to hold your contractor accountable to a very vague scope of work. One cautionary tale from my experience is be wary. A lot of us as public entities, of course, pursuant to our purchasing policies, will have to put things out for an RFP or an RFQ or a formal bid process, and we assemble a set of documents to solicit that input. Be wary of simply flipping that around as your scope of work, or if you get a contractor's proposal, be careful about flipping that around and just attaching that as the scope of work. Why would that be? Well, a lot of times that RFP, right, is a little more laudatory, a little more qualitative. Sometimes it says may, or this is what we're aspiring to. And if you just flip that around and say the contractor will complete the scope of work as set out in their proposal, well, what if their proposal had a couple of different pay options? Or had a couple of different alternatives? You know, you as the public entity, if you want X, Y, or Z, we can do any of those things, but if you sign a contract that says we can do any one of those, which one did you just hire them to do, right? So be careful of that. Make sure that you're taking a close look of what you want in the scope of work. The other thing with RFP documents is a lot of times they have may language, permissive language, rather than shall. And in my world, sometimes in trying to hold a contractor accountable to their proposal, we're pointing at language that says, contractor may provide this, or contractor for its clients sometimes provides this service. It's hard to point to them and say, you shall do that, when it's simply permissive language within their RFP proposal. The contract payment terms, as we all know, those aren't just the terms that address how and when the contractor is going to get paid. A poorly drafted set of payment provisions can create hidden costs. They can greatly influence leverage during a contract negotiation and the implementation of a contract. Do many of you get those front-loaded contracts, right, for services that says, Well, here's our proposal. You'll pay 90% of the contract fee up front and 10% when we're done. You get those? You like those? What? Ask yourself, well, why is that? Why do we, right? It's always a fair question. Front-loaded contracts, in my opinion, severely hamper your potential leverage as performance goes on. One area where I think they're used quite a bit is software contracts, other types of professional services contracts. I think it's always appropriate to try and negotiate against those, break that down into progress payments or something like that. Is it really necessary that we have a front-loaded contract in terms of payment? All right. What about fixed fee contracts? I'll give you X for a fixed fee. Do we know what the X is? What are the inclusions and exclusions? For public construction contracts, that's particularly important. Improvement projects. We'll do the addition to your recreation center for X dollars. Do we know what things are included when they do those improvements? Or are we going to be surprised by change orders or additions? So spend a good amount of time defining what are the inclusions and exclusions. Who works with the AIA contracts for large public works projects? Somewhat? Yeah, well, they got a long, long list, as you know, right? I think it's probably more than a page or so of what's included and what's excluded, right? If you're using those kinds of boilerplate contracts, take a good close look at what the inclusions are and the exclusions are, because sometimes pre-negotiation, you're going to hear, well, all those things are included, but in the boilerplate of those AIA documents, they may be noted as exclusions. Do our payment provisions clearly spell out how adjustments are made? Who has the authority to approve adjustments to the price? What is the process for approving adjustments to the price? You all, everyone has purchasing policies, purchasing guidelines, more or less, for their entities that they work with, right? They ought to be consistent with that so you don't have surprises. And in support of your own staff within your organization, need to make it clear to them, the people who are implementing the contract, what the procedures are. If they're in the field and they need to make a price adjustment, it needs to reflect what your purchasing policies require. Outside of the price of the labor or materials or services that you're getting, have you properly dealt with expenses and expense accounting? Do the provisions regarding expense accounting get you the documentation that you need, right? Particularly looking down the road in terms of justifying expenses, making the auditors happy. If it's a grant contract, are you getting from the vendor, in the first case, all of the proper forms and documentations that you'll need to turn around and provide to your granting agency, right? So that you're not chasing that stuff down long after you pay the invoice in order to get the records that you need to make an auditor or a granting agency happy. I have when I'm working with members, our CIRSA members, and previously when I was a municipal attorney working with clients, kind of had this rule of thumb with regard to payment provisions. We kind of know as the people, if you're the person who's been dealing directly with that contract in the here and now with the other staff members who understand the scope of work, understand what we're doing, that's one thing. But my test is, after that contract is fully implemented, and someone down the road, maybe a year or two after the project is completed, they pull that contract off the shelf and they look at it, can they say to themselves, yes, I can see from this document what we got, right, and what we paid for it. And that's a good way of looking at the level of detail that ought to be in your payment provisions. Particularly when we're dealing with public funds, I think that's an important accountability issue. All right, let me take a little pivot and talk about what really is a contracting essential for public entities in Colorado, but not the focus of this presentation. We all are familiar with TABOR, the Taxpayers' Bill of Rights, right? So just a little sidelight on that and why it's a contracting essential. So the source, the Taxpayers' Bill of Rights, has all sorts of provisions. That one that applies to public entity contracts is a provision in there that says basically a district within the meaning of TABOR, right, may not enter into a contract for a multiple fiscal year direct or indirect debt or other fiscal obligation whatsoever unless you have voter approval in advance. That means if you have a contract that spans more than one fiscal year, you have to have voter approval in advance unless you can work through that requirement in some other way, right? And what's probably the most common way to do that, right, on a day-to-day contracting basis? That's to include the non-appropriation clause, right? The clause that says that any obligation for our public entity to pay money in a future fiscal year, right, is subject to budgeting and appropriation by whoever has budget control over that expenditure, okay? So it's essential to have that language in your contract. Make sure that you work with your contract experts and your counsel to then ensure that any contract you have that spans multiple fiscal years does have a well-crafted non-appropriation clause if that's the way in which you're going to ensure TABOR compliance. You all probably have within your own organizations and in coordination with your own counsel's office, you have probably standard non-appropriation clauses, is that right? Yeah. So make sure you get that in there. I did include 2 examples of non-appropriation clauses at the end of my slide, but you'll want to work with your team and make sure you get that language in there. It's got risk from a couple of different perspectives, and it can create kind of a false expectation if we don't attend to TABOR compliance correctly, because sometimes people who don't, in the public world, people who didn't like that contract from the get-go, right? If that contract spanned multiple fiscal years and they don't see the TABOR clause, they go, oh, well, this is an easy way to get rid of that contract, right? It didn't have a TABOR clause, so it's void. Does that really magically make all your problems go away? Probably creates more problems, right? So you want to attend to your TABOR issues up front. All right, let's pivot back to some risk transfer stuff and talk about indemnification clauses. Just starting obviously with the most basic concepts of an indemnification clause. You've got these in a lot of contracts. You're sometimes asked to give them to another party. Quite often you're requiring them to another party. What is an indemnification clause at root? Right? An indemnification clause is simply an agreement whereby one party, the indemnitor, agrees to defend and to assume the liability of another party, a counterparty, right, the indemnity, in actions brought by third parties. I very early on in my career learned the hard lesson that actually indemnification clauses don't apply usually to disputes between one party to the contract and another. It's like you breached the contract and it had all these consequences, you're going to indemnify me from all these other third party problems that are going on because you breached the contract. Well, no. The indemnity is there for protection against third party risks. They're everywhere, aren't they? Yes? They're everywhere, right? Why not from a vendor's perspective, from an independent contract? The heck, you're just buying a widget and on the back of a purchase order, what's there? Indemnification clause, right? Grant agreements, construction contracts, leases, easements, purchase orders, software licenses, engineering, right? Should we, when we're entering into contracts with another party, should we accept an indemnification that's asked of us for the benefit of the other party? Should we really be hanging around with those kinds of clauses? Let me start with this hypo from a public entity's perspective. Your entity is hiring a contractor to perform janitorial and maintenance services for its buildings and facilities that you own, right? And just as I suggested, the contractor, we're good, we found somebody, it looks like they're a great vendor. They say, yeah, we got to form a contract, we're going to send it over. And it's got an indemnification clause that it says the owner, you, your public entity, agrees to indemnify the contractor against any claims arising from this agreement and from the performance of the work. It also says that you, the public entity, agree to maintain general liability insurance at your own expense and to name the contractor and its principals as additional insureds on your coverage. Can you agree to that? Should you agree to that? What do you think? Let's start with this question, right? Breaking down the non-legal aspect of this. It's like, why isn't the contractor instead agreeing to indemnify us, right? In the larger world, right, at its root, at its most basic building block, foundational level, the whole idea of seeking independent contractors, right? It may be for non-legal reasons. Maybe you've got staffing issues, or you need outside expertise, or you're short on resources or the time. So you're looking for an independent contractor to do work on your behalf. But in engaging an independent contractor for services, one of the core purposes of doing so, right, is to get protection from suits and liabilities that arise in relation to the work, right? And to shift risk to that other party. We're paying and hiring the contractor to do the work. They ought to be responsible for their own risks, right? And they should instead be protecting you and your public entity for suits or liabilities that arise out of or that are caused by their acts or omissions, right? From their perspective, does it hurt to ask? Probably not, right? If you have an independent contractor whose form suggests that you, the public entity, will indemnify them, maybe it's a never hurts to ask. But keep your radar up for those provisions. They're lurking everywhere within boilerplate, right? I think the right answer to that question is to answer the question with a question, and that is, in this relationship, instead of us indemnifying you, the contractor, the vendor, shouldn't you be indemnifying and protecting us, the public entity? Right? We all agree with that proposition? Yeah. In fact, you probably have a policy, right? You may be one of those organizations that has that express policy in your purchasing policies. Did anyone have that? A prohibition on that kind of thing? Yeah. So use that to your advantage. Show that to the vendor. Tell them, no, that's not the way it works. When we hire for independent contractor services, it's your obligation to do this for our benefit. And see if you can get that provision out of there. Now, sometimes it's not always possible. Is that true? Or sometimes it seems like it's almost impossible to get rid of that indemnification clause, right? Who all deals with railroads? That's about where it seems impossible, right? And you ain't going to get out of the indemnification in that one, right? Sometimes state grant contracts. So this kind of shows that with respect to the issue of indemnification during a negotiation, sometimes at the end of the day, it really does boil down to this core golden rule of indemnification. And that is the party that holds the gold is the one that's going to rule, is the one that's probably going to have the upper hand in determining this outcome of this negotiation regarding whether or not there's indemnification and what it says, right? So if you hold the gold, right, if you're the one hiring and you're holding the money, or you're the entity that's holding an approval power, maybe that's true like for tap fee agreements or development agreements or subdivision agreements where that contract is part of an approval power that you're exercising, right? Or you have plenty of options for vendors to choose from, you hold gold in that situation. And you want to use that to your advantage to require that the other party, right, agree to indemnify you and agree to your version of the indemnification paragraph, right? Recognize, however, that sometimes it's the other party that's going to hold the gold. But I like to think, particularly in the public entity contracting world, right, that we generally hold the gold. We want to be reasonable with our vendors. We want to have good, long-standing relationships with them. But if you're dealing with a situation where the other party's being intransigent and saying, no, you need to indemnify us, if you hold the gold, you have to decide whether you're willing to say, no, this is our line in the sand on that issue, right? If you hold the gold, require indemnification for the benefit of your entity, but be reasonable and flexible and reject indemnification clauses that are running the other direction. I did include on one of the last slides a sample indemnification clause for you as well, but if you use your own forms, right, you have your own standard provisions, those are what you're going to want to use on those issues. As I said, sometimes this golden rule of indemnification does end up with that situation where the other party holds the gold, right? So how many of you have a policy that says what I call the Russian style of negotiation? The other party says, will you indemnify us? And the answer is, niet. Anybody? No, we don't do it. We don't do it. Yeah, this is not the focus of this presentation. The municipal attorneys, the public entity attorneys will explore this with you forever, if you would like. And that's the question of whether a public entity, in fact, has the power to indemnify another party under the Colorado Constitution and some other principles of constitutional law. But sometimes, in practical terms, that hardline approach can work. There are public entities that take that position, that basically say, for constitutional reasons, right, or because of some provision in our home rule charter or our rules and regulations, we simply cannot agree to indemnify another party. We've never done it. We're not going to do it here, and that may have success for you. Who's had success with that approach? Anybody? Sometimes. Yeah, in my attorney world, I work more directly with clients. That sometimes what happens is you have that situation and you say no, but the other party, their response is, "Niet, we won't remove the indemnification requirement that we have upon the public entity." And you really, really want that contract with that vendor, right? That's what I used to call the municipal attorney's dilemma. It's like I had a client who really liked this vendor, really wanted their services, and just couldn't agree on who was going to indemnify whom, and they were never going to remove their indemnification clause. You don't have to answer that question for me here and now as to how you handle that, but it creates that dilemma, right, where ultimately are we going to move forward where we agree to indemnify another party. And sometimes it's just a reality. Who's been successful in removing an indemnification from a railroad contract? Anyone? Anyone? No. State grant contracts has kind of been back and forth over the years, right? I looked this morning on the state controller's website for the most current version, which is as of July of this year, for their standard grant agreement that they push out to the granting agencies, which sometimes, hopefully are using the most current form. But in the state grant contract, there's actually a note in there for the draftsperson on the state side that says, if the grantee is a public entity that has statutes, regulations, or constitutional requirements that prohibit them from indemnifying the state, then the contract drafter has the flexibility to remove those provisions. So if you're on the receiving end of a state grant contract, see if the other parties who are putting that contract together recognize that's there, right? Use Sam Light, the SORSA attorney, as a crutch on that and said, yeah, I went to this presentation. It said there was a comment in the margin that you could remove these indemnity paragraphs. It's what it says, right? And hopefully you'll have some success in getting those removed, okay? Even if it's another party that seems like their view is always going to be niet, in my perspective, it never hurts to negotiate, because even if the indemnification clause that's being asked of you can't be removed entirely, it may still be possible to reduce the scope of your obligations with respect to that indemnification. In particular, right, look for removing language that requires indemnification for risks that are outside your control. Try to get removed indemnification for risks that reasonably ought to be resting with the other party. Recurring examples that I see in reviewing contracts for our members on that are software contracts, where you as the public entity are being asked to indemnify the software provider against third-party claims for breach of intellectual property rights. Like, hey, software vendor, you're the ones who dreamed up this fancy software. We got a lot of great minds here, but you're the ones whose intellectual power created that. You should be protecting us against intellectual property claims for that type of contract. Another one like that is hazardous materials indemnifications in construction contracts. Yeah, you're the owner of the property or the facility where the construction work is being done, but if the contractor is actually using hazardous materials as part of performing the work, you ought not to be agreeing to a blanket indemnity to protect them against all hazardous materials risks. They should be bearing the risk for the hazardous materials component of the project that they're handling, right? And then also try and remove risks that aren't associated with the type of contract at issue, okay? With respect to the interplay between indemnification and insurance, as I mentioned in my top 5 takeaways, probably the most critical best practice that you already all know of, but part of my mission here today is to remind and empower and embolden you, is to make sure that every contract you enter into has appropriate insurance requirements with specified limits, right? And that contract also in writing, right, in addition to requiring that the other party carry specific types of insurance for specific limits, also expressly agree to name your entity as an additional insured. Has anyone ever had that fleeting sinking feeling in a negotiation with a other party to a contract where they kind of willingly accept the indemnification paragraph, but they say, well, we can't really agree to the insurance provisions? How do we feel about that? It's like, that makes me more nervous, right? Because isn't that insurance, it's the financial backstop for the indemnity, but they can kind of pull on your heartstrings on that issue sometimes, right? Well, we just don't carry insurance. Have we heard that? Or this is a very low risk contract. Do we really have to carry insurance? Well, that's for you all to decide, right, what types and limits you want, but I encourage you. I do tell folks, that one of your responses to that is, as public entities, we're responsible for public funds and proper management of public agencies, and if you're going to swim in this pool, right, then you have to have the proper stuff, right, and that includes having insurance, right, walking and talking and doing the things that contractors do when they're contracting with public entities. So among the other purposes, the insurance provisions, they serve as the financial backstop for certain promises in the indemnification clause. Well, how does that really work technically? Because their insurance, like most insurances, probably has a contract exclusion, right? That insurance says we will not insure you, the insured, for any type of liability that flows from a contract. And isn't the indemnification paragraph a contractual commitment? It is, right? But the underlying linkage between the two, of course, is that concept of an insured contract or additional insured status, right? And an insured contract, right, I've given you here in the middle of this slide just one of the definitions of what that is. That's from one of the Insurance Services Office boilerplate forms, right? An insured contract includes that part of any contract or agreement pertaining to your business under which you agree to assume the tort liability of another party to pay for bodily injury or property damage to a third party or organization. Okay? So that provides, as long as you've got all the magic language in the contract, right, their contractor's insurance is going to automatically attach to their promise to protect you to the extent it falls within the definition of an insured contract. If it doesn't, but you still want to have additional protections, right, you can call out additional types of special coverages, or you can get indemnification. Can you agree to an indemnification that's broader than insurance? Sure, absolutely. It happens all the time, and by their very nature, indemnification clauses are broader than insurance. From where you sit as a public entity, if a contractor asks you, can you limit our indemnification clause? Can we add language that says, our indemnification obligation shall be no broader than the types and amounts of insurance that we carry? Good idea? Maybe, maybe not, probably not, right? So here's a sample just to give you another example of the language about how the two tie together. This is from CIRSA's liability coverage form, right? This would be our language running the other direction when our public entity agrees to indemnify and extend the member's coverage to that third party. But running the other direction language is quite often the same, right? Who becomes a covered party under our language is any person or organization to whom the member is obligated to provide coverage because of a written or oral contract, but only for damages or injuries arising out of the premises or operation of the member. Here's another example. I know it's probably not legible on the screen there, but this is also from an ISO form, right? Who is an insured party with respect to these kinds of contractual provisions? An insured party includes a person or organization whom by written contract is included as an additional insured, but only for tort liability caused in whole or part by the named insured's acts or omissions. The benefits of obtaining additional insured status: it reinforces the contractual indemnity, provides the financial backstop to the extent there's coverage, right, that covers that portion of the contract that is an insured contract. Even if the indemnity provision, right, itself for some technical reason turns out to be unenforceable, if you're named as an additional insured and there's a third-party claim that falls within that coverage, you may still have protection from your vendor's insurance, right? Other benefits of being named as an additional insured, you get direct protection. In the public entity world, when a third-party claims arises, what's the thing we want most urgently and immediately? We want the contractor to be responsible to defend us, right? And we don't want to have to be in a position where we have to expend dollars to defend ourselves and then chase down reimbursement. So a well-drafted defense and indemnification clause gives you a right to an immediate defense, right, through the counterparty's insurer if they're required to indemnify you against that risk, right? That's a lot better situation than compared to trying to chase down those expenses later after they're incurred. It gives you direct protection for indemnity for liabilities that are within the scope of coverage, and you can look directly to the named party's insurer for defense and indemnification within matters where the indemnification overlaps with the coverage provided by the contract. Some technical nuts and bolts about additional insured things. If you're requesting additional insured status for your public entity, a couple things to look for and confirm. Make sure that the contractor's coverage allows it. That's pretty commonplace, but sometimes they may have some unusual insurance product and it may not allow for it. Well, how do I find that out? Well, once in a while you might have to ask for a copy of their policy, right? That sounds like fun. I thought I could just rely on the indemnification provision in the certificate. I don't have to worry about this. Heck, well, what else are we going to do on the weekends anyway, right? We can get a certified copy of their policy and make sure that it does exactly what, particularly in the high stakes ones, right? Where is a huge project or huge dollar value or a huge third-party risk. It may well be the case that you need to pull or ask them to produce a copy of the actual language of their insurance contract that covers, make sure that their insurance language actually does what you want it to do, right? Some of the things to look for is that maybe that additional insured status is provided only if it's endorsed onto the policy. If so, then you want to ask for and make sure that you receive and have in place the additional insured endorsement. A lot of times the other party's insurance contract will say that if we do name another party, your entity as an additional insured, then the amount of coverage that we have for the benefit of the additional insured is not necessarily the overall limit that's available under the policy, but it's the amount of insurance that you required in the contract. Okay, so you'll want to look at that. You'll want to make sure you obtain certificates of insurance that we're going to talk about in a second, and then actually verify with your contractor what their limits of coverage are. Common question we've been getting lately, although it's been around for about 5 years, is most of us are public entities subject to the tort limits under the Colorado Governmental Immunity Act, right? Well, they went up this year, right? Because of the inflation factor that's in the statute, right? And now the overall aggregate limit's about 1.195 for 1.195 million as an aggregate limit of liability. So how many have bumped up your limits for that? Or do we still do contracts where we require $1 million of liability coverage from the other party? Kind of a mixed bag, right? Yeah. If it's a high risk and you're worried about, that full limits case, and you may get pulled into it, and maybe a particularly horrific risk where you're worried there might be the possibility of full limits judgment against you, recognize that if you're going to get protected through that contract, $1 million in coverage isn't going to get you all the way there. And so you may want to think about bumping your increments up in that case, right? If your entity is asked to name another party as an additional insured, go back to my earlier suggestion, right? Is it really necessary? Do we actually hold the gold in this situation? Is our negotiation strength such that we can reject or significantly narrow the request, right? You'll need to check with your own carriers on this, but there's some general principles that happen when you agree to name another party as an additional insured on your coverage, probably a particular sensitivity for public entities, but by naming another party as additional insured, you're sharing your limits of coverage with them. You're also sharing your coverage with a party that may not necessarily enjoy the same protections and immunities that your entity has under the Colorado Governmental Immunity Act, right? They're not protected by that governmental immunity provision, so they can't argue there's been no waiver. And if there's liability, they may not have the caps under the CGIA. They won't have the caps under the CGIA. And of course, if there's a claim and there's a loss history that attaches to that claim, then the loss history that attaches to the part paid for the additional insured becomes part of the loss history of the member, the named insured. Okay? All right, where does all that leave us, right? With respect to our original questions, yes, bad contracts ain't illegal, and you can agree to overly broad indemnity and insurance provisions, but don't. Instead, particularly when dealing with independent contractors, have the provisions run for your benefit, have them run the other direction, require that they indemnify you, that they carry appropriate coverages of appropriate amounts and types, and that they give you additional insured status. If you're in a situation where you do have to give additional insured status to another party, try to limit that to solely your entity's own negligence, solely through its own employees, and solely for bodily injury or property damage. That gives it more likelihood that it's going to attach and fit very neatly to simply being no more than a covered contract under your insurance coverage. A couple of things to keep an eye out with respect to indemnities and requiring additional insured status. Recognize, I've given you the citation at the bottom there. In Colorado, we have for construction contracts a provision that says we cannot overreach on those as public entity owners, and that is we cannot require a contractor to provide an indemnification or insurance that protects us, the owner, against our own negligence. Okay? So keep it attuned to that. There's some complicated language in the statute on that, but you'll want to make sure you have that in mind for your construction agreements. There's also a similar statute that applies to professional services related to public works contracts, and if you want to write down the citation for that, it's Colorado Revised Statute Section 30-50.5-102. That also says when you're dealing with an architect or engineer on a public works contract, you cannot require them to protect you against the owner's own negligence, and you cannot require indemnification beyond their own pro rata share of the actual underlying liability. All right, let's talk briefly about certificates of insurance. You may even have this in your own contract, right? In your boilerplate, you said prior to your start of services, you're going to give us a certificate of insurance, and it'll name us as a certificate of holder, and the certificate's going to say you won't cancel your insurance unless you give us 30 days notice, right? There's an illegible version of a Accord certificate of insurance form. What's the point of requiring these things, right? Well, here's a little bit of the legal aspect of that. Well, they're informational, right? The certificate of insurance is a quick, easy, we hope, way to confirm that the other party that's providing that certificate has the types of insurance that we've asked for with the appropriate coverage limits, right? And has other details in there, including language in there that confirms that we're listed as an additional insured. But recognize this on the legal standpoint. The certificate of insurance, we all know this, right, is not itself a contract of insurance. It's not directly enforceable against the named insured or against the party that issued the certificate, the broker or other party administrator that issued the certificate of insurance on behalf of the named insured. Okay? There's the language right there that's a little bit unsettling, right? But we're still relying, we read that, but we're still relying on the certificate, right? Yeah. This certificate is issued as a matter of information only and confers no rights upon the certificate holder. Well, great, thanks. Wonderful information, right? But it's still what we do, right? That's the industry practice. That's how we confirm these things. Yes, as I mentioned, half seriously, half facetiously, you can, you know, and maybe sometimes you're going to drill down and ask for the policy and ask for the actual language of the policy that talks about additional insured status. But the certificate is what we all use to confirm that coverages are in place. Just recognize the certificate itself, however, does not, right, amend or extend or alter the coverage afforded by the policies. It's the underlying policies that matter. A couple things to look for when you get a certificate of insurance from your counterparty. Hold it up next to your contract language and make sure that all the boxes are checked and numbers are put in correctly so that you've got the type of coverages, or the boxes are checked that we got the type of coverages that we're requiring under the contract, that they're for the limits that we require, that we've got other technical details completed there. One of those that we see quite often that is actually a place on the certificate to note this, but it's often left blank, and that is, does the underlying liability coverage extend coverage for completed operations? We want that. As owners, project managers, we want that to make sure coverage is in place for claims that arise after the work is done. So check that, require that, make sure your insurance language expressly says your general liability coverage shall cover completed operations. Yes?
So is it more important to have the language in your contract about what's covered, or do you want to make sure that it is in the policy, written into the policy somewhere place?
Yeah, if we get it, it'd be nice to have them all aligned, right? Yeah, but if we get that AI status and it's in the underlying policy, then we're going to get the benefit of it, even if we didn't say it. But the risk is perhaps they modify coverage, right? In a renewal year, they find out that it's cheaper to drop some coverages, the contract didn't require it, or some other things like that. It'd be nice to have the contract say it directly so I can point to that. Said, no, it's general liability, and it's broad form, and it has to have these endorsements, and it's got to include completed operations. So then you can point, and it would be a breach of contract, right, for you to not provide that coverage throughout the full term of contract performance and after the contract is completed. Yeah. Thanks for the question. Yeah. And I was supposed to mention the question before I answered him so that they're on the recording. And the question was, is it more important to have the contract itself include language requiring coverage for completed operations, or is it enough that the insurance policy itself have those provisions? And again, it's good to have them both aligned, but at the end of the day, if it's in the policy, even if we forgot to mention it expressly in the contract, then it's going to be there for our benefit. Okay. Cancellation notice provisions, take a look at those. One of the things, I'm going to break down a couple of things to keep an eye out for in the certificate. Sometimes, just like this sample certificate I've got here, they don't check that box on whether the aggregate applies on a per project or per policy basis. That can be a pretty important one, right? Particularly for public works contracts. If you're dealing with a contractor that's got a lot of different jobs going on, and maybe they've got limits that are on the lower end, making us a little uneasy, right? We want to consider requiring that that aggregate limit apply on a per project basis rather than on a global basis, and that would be reflected on the certificate. Notice is always an interesting thing. Here's the older form of the notice provision of a certificate of insurance, the older accord form. It says that should any of the contractor's policies be canceled before expiration, the insurer will endeavor to. Oh, well, that's comforting, right? They will endeavor to, and who all's been around long enough to know then we negotiate, well, no, take out those words, endeavor to, all right? If we ever knew what they meant to begin with, right? So that's all that said. It was endeavor to. There's no direct liability on behalf of the person who issued the certificate if they failed to give that notice. Here's the more current version of the accord notice provision. It said, should any of the above described policies be canceled before the expiration date, notice will be delivered in accordance with the policy. There's some interesting words missing. Notice will be delivered. To who? To you, the owner? No. Whatever the policy says, that's how notice is going to be provided. This question has actually been litigated in the case that I've mentioned here, because the question was, if it says that, and am I holding the certificate, that means as a certificate holder that this must be duplicating the notice provisions for my benefit. So I'm always going to get notice from the insurer before the contractor's insurance is canceled, right? The answer to that is no. It does not consign the whole issue of notice for the benefit of the certificate holder. It says that notice is only going to be given per the terms of the policy. So that can be a little discomforting, right? So one way to solve that is, doesn't solve every situation, but a belt and suspenders approach is to include in the contract additional express obligation for the contractor itself to also give you notice whenever they first learn that their insurance is about to be canceled or non-renewed. The special provision box is important. That's where you get what you really want. That's where your entity gets listed as additional insured. You'll want to look and make sure that has sufficient description of the actual project. The example here in the materials is actually a certificate running the other way, where one of our members was using the parking lot at First National Bank for some parking for a 4th of July festival, right? But we've got a sufficient description of what the additional insured status is provided for, right? It's AI status as respects the use of land owned by the bank, right, for parking, and that's the risk being covered by the AI status. Okay, let's turn quickly to remedies provisions. Make sure that you take a good look at the remedies provisions. Avoid boilerplate that has inappropriate waivers or caps on damages or inappropriate timing or forum. I think our greatest interest as public entities with respect to remedies clauses is what? We want to get the project done on time and on budget. So we want remedies that help us do that. Be careful of remedies that give that away. As public entities in particular, I think you want to expressly reserve your right to injunctive relief. So if a contractor is not performing, you can ask the court, hey, they're in breach of the contract. I want you to enter an order that they need to get some things done. Be careful of if it's a construction project, you don't want to have very de minimis delay damages where there's really no incentive to get out there and get the work done. Be wary of boilerplate that waives all these weird legal terms that seem like only things for the lawyers, right? You know, in the block letters. And the parties hereby waive all consequential damages and punitive damages and lost profits and so on. You could be giving away pretty important pots of money, right, if you agree to those things. So just think critically about those. Waivers of subrogation, think about what those are. In the broad context, waiver of subrogation, of course, means that the parties will only look to insurance. If you do that, however, are you giving something away? When we're dealing with public funds, and are we giving away the ability to make a pot of public money whole, right? Or a pot of public quasi money whole if you're in a pool, right? Wouldn't we want to reserve our ability to go after the third party who's really at fault in that situation? Damages caps. Who's ever seen this? The total and aggregate liability of the company shall not exceed the total amount paid. Yeah. Where did that come from? It just sounds convenient. Sounds like a good way to limit your risk if you're on the contractor side. But does that dollar amount of what you're about to pay have any bearing or relationship to the amount of potential risk? How do we resolve that? How do you all resolve that? Try and get rid of those? Yeah. What if you don't really hold the gold and it's kind of this back and forth? Sometimes there's that practical, well, let's bump it up to 2 times. Or 3 times, or 5 times. That's still an arbitrary number, right? Still a kind of an inconvenient or inelegant solution to that. But you do want to remind the contractor, hey, that might work for you in the commercial for-profit world, but for the public sector, we simply, that's not a reflection of the risk that we're taking on. So while those kinds of caps, particularly in services or consulting contracts, are quite common, can be difficult to remove, there are really good reasons to remove those. Think about timing and performance provisions. Have you ever seen this? If you're the customer here, the customer agrees that any legal proceeding under this agreement must be brought within 12 months, and if it's not brought within 12 months, then all claims are barred. Right? Do we see those a lot? Yeah. Yeah, on the risk side, of course, it cuts off and gives us certainty about how long risks are going to last, but is that really helpful to us as a public entity? We may even cut off risks or claims that you didn't even know you had if the time period's particularly short. Be careful of jurisdiction and venue provisions. Who's ever agreed to a contract that says the parties hereby agree that this contract shall be governed by the laws of the state of Mississippi, and forum for any dispute shall be in the district courts for Jackson, Mississippi? Who's excited about going to Jackson, Mississippi? Right? Recognize that as Colorado public entities, I do encourage you to use use that to your advantage. Tell them, look, this is a Colorado public entity you're dealing with. You're going to be performing this contract in Colorado. Colorado law should govern. Jurisdiction and venue for any dispute should be here in Colorado. The practical effect of agreeing to out-of-state jurisdiction and venue is you may more readily throw in the towel, knowing that you might have to find an out-of-state attorney to handle the claim out-of-state under some laws that we were not even fully familiar with at the time we signed the contract. So you do want to battle uphill against those. Arbitration, who's, just as a general sense, folks generally amenable to arbitration? Yeah, but why not make it an option so that we've got all options available to us? So if you see binding arbitration, maybe you want to say, well, add just a little bit of language, right, that says it's voluntary and consensual. We agree that we'll try to mediate or arbitrate, but if we can't successfully, through a voluntary process, resolve our dispute within a certain amount of time, then we have the ability to exercise our legal remedies. Okay? That's about it. Just want to wrap it up, get back up to the 40,000 foot level, and remind you that with all these risk transfer provisions, maybe we're not as focused on that 15th page of boilerplate as we would be if we were ropeless on the 34th pitch of LCAP, right? But we want to pay attention to those risk transfer provisions, particularly vendor boilerplate if we're willing to use theirs. Contracts, and give those things the time and attention they deserve. I do encourage you to develop and use your own contracts and put your vendors on notice. Be wary of boilerplate, but be reasonable and pick your battles with regard to the bad boilerplate that you want to battle against. And then always good contracting, both in negotiating and in carrying out a contract successfully is a team effort. And use your team as a great resource to get great things done. And with that, I'm going to stop and open it up for any questions that you have. And thank you all very, very much for the opportunity to come visit with you all today. Thank you.